I think what my case exemplifies is the impossibility of getting help. There is simply no way to get help.
A phone call on July 2nd, 2010 changed the course of Linda's life.
I was just freaking out. I couldn't believe it. July 2nd, she called me. Just out of the blue, I get this phone call from my mother.
Linda's mother, who had started showing signs of dementia, was able to use her cell phone to tell her daughter she had been taken out of her home and placed in an assisted living facility.
And I get down there and the facility is saying, you're not allowed to see her, you can't go in.
Linda believes her mother had been targeted because of her wealth and dementia.
Her tax preparers went to her house, broke in the door, took her out, and hid her in a facility. I have a photograph of the wood of the door frame splintered where the deadbolt broke through the wood.
The tax preparer admitted to forced entry during this deposition given to us by Linda.
Well, you broke into the home, right?
I broke the frame.
And there was a locked door that you pushed hard enough that the door opened, correct?
Correct.
In her deposition, she said she forced entry to help Linda's mother, Carol, move because it was an unsafe environment for Carol and the man she lived with at the time was abusive to her. But court documents say that Carol and her companion had resided together for years and had treasured moments together. Linda told ABC 10 her mother's partner was not abusive ever and that he and her mother adored each other.
Have you ever, during the time that you were with Carol, you ever struck her?
Never.
You ever abused her in any way?
Never.
5 days after Linda's mother was taken from her home, her estate planning documents were changed, and she was placed under the conservatorship of a step-granddaughter, someone of no blood relation. Linda, her only daughter, said she had no idea any of this happened until a month later, when her mom called her.
You can't mentally process that something like this can happen. You know, people at the time would ask me, what country was she in? Southern California.
Linda said she had no access to her mom for 15 months, allowing the door for abuse to occur. Court documents say her mother wanted to have visits from her daughter. These documents also show the facility she was placed in were instructed not to allow any visitors besides the conservator.
So ours was no visitation for about 15 months. Then we did finally get limited visitation. And when we got in to see her, it was, well, she didn't know who I was anymore at that point. She was skin and bones, and we found out in litigation that she wasn't getting fed.
Linda says her mom was abused financially, physically, and she believes even sexually.
People say, well, can you prove this? Well, no, I wasn't in the room. I didn't see it happen. I can't prove that it happened. But there are facility records showing that my mom had vaginal bleeding over a period of time.
Linda's mother had a hysterectomy prior to this.
There are records both from the facility and for hospice and from Kaiser showing that my mother went by ambulance to the emergency room for vaginal bleeding.
Shortly after the bleeding, Linda says the facility terminated a male caregiver that worked alone at night.
There are these records where everyone has to fill out what they did at what time, and it shows who was on what shift. When we were in discovery and we were requesting records from the facility, we want all of your care records for this time period. Like, well, they can't find the records for the 6 weeks before she went to the ER.
In a deposition when questioned about sexually assaulting Linda's mother, the male caregiver pled the fifth.
Have you ever been alone with Carol Hahn in a restroom facility?
Again, I'm going to direct the witness to assert his Fifth Amendment privilege against self-incrimination.
Well, they lose the care records, they terminate the male caregiver, and they really quickly transfer my mom out to another facility.
The new facility is where Linda's mother passed away in 2013. Following her death, Linda sued multiple people involved, including her mother's conservator and the care facility, for assault, negligence, and intentional infliction of emotional distress. It remains the longest civil trial in San Bernardino County, and while the jury found in Linda's favor, the judge declared a mistrial after releasing one of the jurors. Linda said the trial alone cost around $1 million. That's why they decided not to retry it. The outcome of her mother's conservatorship outraged Linda.
that the system is very broken, and the system will not change until we, as citizens, residents of California, demand that change.
That's why she co-founded the nonprofit CEDAR, the Coalition for Elder and Disability Rights, with her partner, Richard Calhoun. CEDAR was created in 2014 to promote rights for California conservatees, but trying to change the system hasn't been easy.
If you want to talk about a lone wolf, I walked these halls for the first time on this topic on July 19th, 2010. And everybody looked at me like I was crazy. In 2010, 11, 12, nobody heard of the topic. No one would believe it.
Today, they're the few, if only, conservatorship advocates in California, let alone the United States.
Person on there for 3 thefts, and now you're giving them a fiduciary responsibility. It doesn't take a rocket scientist.
And they're well-versed on nearly every aspect of the complex field. Their drive is sparked by their own trauma, unlike the many others competing for elected leaders' attention.
We will work with anybody that will work with us, but it is difficult. We're competing with lobbyists, and lobbyists are getting paid $1,000 an hour, and we're getting paid nothing, and we're self-funding our expenses.
Yeah, our joke is that their suits cost more than our cars.
It's absolutely, it's true.
But when they do get legislators' attention, it's proven to be powerful.
The stumbling block for CEDAR has been getting an elected official, one of the 40 senators or one of the 80 assembly members, to introduce our bills. Once our bills are introduced, they pass.
They pass with flying colors. 3 out of the 4 bills CEDAR has sponsored passed unanimously. The 4th had a vote of 100 in favor to 4 opposed. Their success in part is because these bills simply help ensure basic human rights for those under conservatorships.
Prisoners had more rights than a conservative that has done nothing wrong except grow old.
CEDAR's biggest problem with the current system is the lack of consequences for not following the probate code.
Think of the motor vehicle code, think of the penal code. Every section has a penalty if you don't follow that code. There is not a single penalty or consequence for not following the probate code, so nobody follows it. Imagine the chaos on our roadways out here if there was no speeding tickets, no running red light tickets, no parking tickets. We'd have chaos. And that's what we have in probate court.
What bills you're trying to introduce now that you're excited?
AB 1062, I believe. And this one is basically a conservator right now can dispose of a conservative's property that is worthless.
But worth is determined by retail value. This bill would give families the opportunity to come in and claim items that might not have value but be priceless to the family. Another bill that would change multiple key aspects of California conservatorships has been introduced by Assemblymember Lowe.
This is Assembly Bill 468.
Lowe serves as the chair of California's Business and Professions Committee, which has oversight of the Professional Fiduciary Bureau. But he says problems with conservatorships in California only surfaced after recent coverage of Britney Spears.
Why is she still in this? Why is her dad making all of her decisions?
But this bill isn't just about Britney Spears. Some would say the current system is a circus.
That is our job, the consumer protection, and we need to be able to have the laws in place to provide voice to those who are voiceless. And especially when it comes down to conservatorships, that's exactly what we're talking about. Individuals who cannot take care for themselves.
Bill 1194 would change the probate code, requiring more transparency from licensed fiduciaries, including reports of their number of cases. It would also require probate court investigators to do more thorough interviews before a conservatorship petition is granted. But many of these things were also included in a 2007 Reform Act, but never came to fruition.
After doing our own research on the California's conservatorships laws, we found that a huge effort to reform the system in 2006 did not take effect due to the toxic economic recession that started in 2008. In addition, the laws did nothing to help people avoid conservatorships, create resources for families, or provide funding to make existing systems work better.
Does your bill give funds, or does it address that? Because it's kind of doing the same thing the 2007 Reform Act did, if it doesn't.
Right. Part of the legislative proposals that we have too is ensuring that we have the policy that was supported and make sure that there are the resources to empower local communities to implement the law.
Assemblymember Lowe says they're working with court systems as well as planning a budget proposal to ensure courts would have the funding to implement the changes his bill would create.
What we don't want to do is set up our court systems up for failure. We need to set them up for success.
And this provides an opportunity for us to, indeed, as I stated earlier, make our laws stronger than yesterday. I respectfully ask for a vote.
And while it's still going through the process of becoming a law,
so we is currently in that of the Appropriations Committee, and if it does pass, it goes to the full floor of the Assembly, to which I'll present that bill.
It's received support from both sides of the aisle.
This is a bipartisan effort. In fact, it is not partisan. This is about helping those who are voiceless.
Fong, aye. Gibson? Gibson, aye. Grayson? Grayson, aye. Holden? Holden, aye. 14 ayes, 0 noes.
And Bill 724, introduced by Senator Ben Allen, creates more regulations around conservatorships and court-appointed attorneys, a controversial topic we've covered in depth in our investigation.
What most court-appointed attorneys are currently doing is they're just acting in the best interest. Well, who's determining that best interest of the person? It should be the conservatee, even if the court says they're not competent, and that's what this bill would clarify.
Now, if passed, both of these bills wouldn't become law until January 1st of 2022, and there's still a lot of work that needs to be done for California conservatorships. But right now, if you want to avoid a conservatorship and ensure that your wishes are executed the way that you want, advocates say the best way to do so is to prevent a conservatorship ahead of time. Now, we compiled a list of suggestions from books, studies, as well as from speaking to multiple experts, and one of their first recommendations is to try and resolve any family disputes.
Now, if you don't want to have a conservatorship, get along with your family members. You can hate them if you want, but don't take it public, and certainly don't take it into court.
The second recommendation is to ensure all documents are in order, particularly these ones that are listed, and to ensure your durable power of attorney is in the hands of someone you deeply trust, as the durable power of attorney acts as an agent on your behalf. Cunningham Legal recommends, if you're elderly or ill, to consider easing someone into acting as your agent over a period of time. And if you believe a conservatorship could happen and you're not against it, they recommend you document that and inform the person you're nominating. If you are opposed to a conservatorship, Dr. Sam Sugar, the founder of Americans Against Abusive Probate Guardianships, recommends recording a video expressing the wishes of the individual, as well as making it clear they expressly forbid the appointment of a professional conservatorship. Our investigation began in early 2020, hearing from a conservatee herself.
I don't know what's going to happen to me.
Throughout this year, we've spoken to many experts.
No oversight.
This process is going to take away your mom's rights.
You are supposed to put the interest of the person ahead of your own interest.
Court insiders.
And do you believe that corruption is happening here in the Sacramento County Probate Court now?
Yes.
And victim.
I've been robbed of time with my mom.
After victim.
My last days with my mom were fought in court.
To uncover a nearly $13 billion system in California susceptible to abuse.
This is a flaw in our system
that can and has caused traumatic emotional, physical, and financial harm to our elders.
No family should go through it. It was hard enough on me, but to watch my mother, who's lived this wonderful, wonderful life, to have it taken away from her, no one should suffer that way.